provisions as written currently and proposed by Welk and OCD.
Okay. In reviewing your direct testimony, I mean, I would suggest and ask you to agree that your testimony and Nemoga's position opposes the core elements of every aspect of the petition. Wouldn't you agree?
I would say that that my analysis, based on 45 plus years of experience, being a former regulator, working as an EHS director on a contract basis for multiple companies and helping with acquisitions and compliance and plugging and all that, is that as written, I do oppose the way it's written right now. I'd like to be able to say at the core, that's like a hard thing for me to be able to say, but I think that there is opportunity here to come up with, modifications that I think Nemoga would probably be acceptable or accepting of, and that I wouldn't necessarily oppose. And I did put things in, like my testimony yesterday, as far as suggestions and so forth that might be considered.
Is that inclusive of things like changing the definition of beneficial use for inactive wells to 3 or 5 years? You're talking about those kind of recommendations?
There's some of those, yes.
Okay. I'm going to get back to that. When approximately did you begin the actual preparation of your direct testimony?
Again, it's like you're asking hard questions because I don't have that stuff right in front of me, but it was about at that same time. So we talked to Nemoga, they hired us and we got started reviewing everything and proceeding from there.
Okay. Did you read the complete revised petition before you began preparing your direct testimony?
Yes.
Okay. Want to ask you a couple questions now, transitioning to your actual testimony. So one of the reasons I'm asking you questions is because in reviewing your testimony, you talk about stripper wells and marginal wells extensively. And I would submit that those were discussed in the original petition and not reflected in the revised petition. So I want to ask you about, in your lengthy direct, you spent a lot of time on this. It's about 50 pages, if my lawyer math is right. And you spent numerous pages talking about stripper wells. So one, what definition in preparing your direct, because it's in multiple places, so I'm just trying to clarify, what definition of stripper wells did you apply?
I'm confused at the question.
Sorry, I gave you a long preface. You spend multiple pages in your testimony talking about alternatively stripper wells and marginal wells. I want to ask you about each category. How do you define stripper well?
How do I, or how did I?
What definition of stripper well did you use when you wrote your direct testimony? Was it 10 BOE or some other?
Essentially 10 barrels of oil a day.
Okay. And what definition did you use when you refer to marginal well in your direct testimony? What definition did you use for marginal well?
Matt, and here now, so I'm going to object. I think that mischaracterizes his testimony. I don't think he defined marginal well so much as he assessed the proposed definition, which I think that would be a fair question.
Madam Hearing Officer, I think that's the crux of my question, is he didn't define marginal well, and the testimony conflates marginal and stripper wells on numerous pages of testimony.
Right. I think it's a good question. What definition did he have in mind when he was writing his own testimony for marginal?
So I'm not sure that I would say in the energy industry, and even with, how marginal wells and stripper wells are done, are treated, there isn't a consistent definition through there, but you would typically look at that as being 10 to 15 barrels of oil a day.
Okay, thank you, Mr. Arthur. So that's what I got from my read of your testimony, is that when you're referring to marginal wells, you're referring to a significant category of wells which in some cases may actually expand the production volumes as defined in New Mexico for stripper wells. Do you agree with that? If we assume that the New Mexico tax code definition of stripper wells is 10 BOE per day, and you're saying that marginal wells can be up to 15 barrel BOE a day, then we're looking at a category of wells that is greater than the total number of defined stripper wells in New Mexico. Agree?
I would say that's probably correct.
Okay, thank you. So you did not pull any numbers or use the proposed definition of marginal wells using thresholds of 1,000 BOE per 12 months and 180 days of production in preparing your statements on marginal wells, correct?
Could you say that again?
So I'm just confirming based on your prior response that when you're referring to marginal wells in your testimony, you are not referring to the category of marginal wells, which are defined in the petition as producing less than 1,000 barrels of oil equivalent in the previous year and having produced for less than 180 days during that period of time.
I think that depends on the, what my testimony is. So did I try to just evaluate marginal wells in a particular analysis and then suggest this was, like discuss them in two different manners? So I didn't use a single definition and avoid the proposal. And I talked about the proposed changes in there. So there's parts of my testimony that refers to that.
Let me ask the question a different way. Is there any part of your direct testimony in which you specifically used the proposed definition of marginal wells?
It's yes.
I'll move on. Mr. Arthur, yesterday you used a rancher example of a rancher or a farmer that walks out and turns on his well every day for an hour. And, in that fact pattern that you described, you're talking about a well that is producing, the rancher's going out and turning it on every day or most days, that well is producing more than 180 days per year, correct?
It is.
Okay, thank you.
In some cases, in that particular case, yes, not in all cases.
So in that case, that rancher's well would not fall within the proposed definition of a marginal well and would not require additional FA, correct?
If it's an and with the production and 180 days, correct.
And we're stipulating that it's an and. Yes, thank you. I'm going to move on and ask you a little bit about, well, strike that. Mr. Arthur, you said you've been working on your response to the revised petition for approximately 6 months. Did you at any time consult with either the petitioner or the Oil Conservation Division to discuss how either of those entities felt that the rule would or should be implemented?
No.
Is there a single section of the revised petition which you did not characterize as unworkable?
I'm not sure, but I don't think so.
Okay, thank you. I want to refer you to a couple items in your direct testimony. So, Madam Hearing Officer, I would like to share screen. I'll try to move through this really quickly.
Thank you, Sheila.
All right, Mr. Arthur, I'm referring you to what is page 5 of the direct testimony PDF, starting on line 70. The section starts on line 68, but I want to highlight for you that particularly on line 72 here, the proposals do not account for the fact that only the vertical section of horizontal wells typically requires abandonment, and that many low producing wells can be responsibly decommissioned for far less than the proposed financial assurance. Would you agree that this section of your direct testimony stands for the proposition that first, according to your testimony, there's a wide range of potential plugging costs for wells?
Yes,
And this seems to indicate that horizontal wells could be more expensive to plug than vertical wells. Is that your testimony?
it could be. And, you know, it depends on the well and the condition of the well and the condition of the casing and things in the well and a variety of different things.
All right. So are you aware of OCD having plugged any horizontal wells?
I'm not sure that they have. I don't know that.
Okay. Would you believe me if I said that OCD's plugged 2 horizontal wells at the request of the Bureau of Land Management or in coordination with?
Would not
Okay.
surprise me.
Are you suggesting in this testimony that the division would require plugs or additional downhole work below the heel of a horizontal well?
I'm trying to suggest that it's not necessary.
Okay. Would you be relieved to hear that OCD agrees and that plugs are not required below the heel?
Would not be surprised.
Okay. So would you agree then that the suggestion in your testimony that your testimony seems to imply that OCD or someone is incorporating increased cost for horizontal wells in the suggested average plugging cost? And so I'm just trying to get at that's not what's happening. And you didn't have any information that you relied upon in presenting this argument to the commission. So would you agree that, to the best of your knowledge, the division is not requiring plugs below the heel on horizontal wells?
I'm simply suggesting in this portion of my testimony that to be clear in that, I'm not suggesting that the division, does require that, but pointing out that it doesn't. And those are just factors that if you're looking at plugging costs, and if you think a horizontal well and it's got a super long lateral, that could add cost to this. And I'm pointing out that that's not necessary.
Well, Mr. Arthur, I'm trying to really respond to the criticism in your direct here, because you say that in line 68, the proposed framework fails to reflect the operational and cost variability of well plugging and abandonment. Then you go on to say that those, or state or really imply that those costs could be inflated because of additional costs for horizontal well plugging. But I think you've answered my question. I'll move on. You talked yesterday with Mr. Tisdale about kind of some of the average well plugging costs referenced in the LFC report. Do you agree or do you understand that the average of those 2024 plugging costs, those were all wells that were plugged that's representative of all wells plugged during that time period by the Oil Conservation Division?
Yes.
Okay. And so that average is the average cost of all wells plugged by the division, not the average cost of problem wells plugged by the division. Agree?
So I don't have the details of of wells, of be able to say problem wells or not, but if the wells are being plugged, that they are probably being viewed as a problem. But does that mean that every one of those wells is complicated from a plugging perspective? Could that mean that one well took $1 million to plug and something else? But I also know, based on what what the division is doing and has done for like its federal monies and submitted in IOGCC reports, that you prioritize the plugging based on risk and problems and those sorts of things.
Did you hear the testimony during his hearing that the division also makes every effort to plug wells in the vicinity of target wells to reduce mobilization, demobilization, and other costs?
I did not hear that, but that's one of the suggestions that I've made to industry and states and so forth.
So you would agree that that's a good practice?
It is.
And that would mean that OCD is not only plugging technically problematic wells.
I'm not saying that they're only plugging technically problematic wells, and I think that in your initial expert's testimony, he showed one well that was a real problem and another well that was not as big of a problem, that were aligned with what you just said about plugging wells near each other so you could reduce mobilization charges and so forth.
And just to be clear, are you speaking of Mr. Powell or Mr. Dede? Was the last witness Mr. Powell?
No, the first witness.
Okay, Mr. Dede.
Yeah.
Thank you. Okay. All right, I want to refer you to line 100 on page 6. You go on to talk about the speculative purposes. I just want to ask you if you heard Mr. Powell's distinction in his testimony between speculative results and speculative planning.
I was not able to listen to Mr. Powell's testimony.
Okay. I want to move on to page 7 and beneficial purpose or beneficial purposes and the definition of that, starting on line 111. Do you agree that beneficial purposes or beneficial use is already referred to in New Mexico Rule 19.15.25.8?
The term beneficial is already included in the regulations, yes.
Okay. And would you also agree that, so basically in 25.8, it says that a well has to be plugged within 90 days if there is a determination that it is not being beneficially used. Would you agree with that paraphrase?
Yes, Jim.
Okay. But would you also agree that there is not a prescribed process for how OCD is to make such a determination?
I agree.
Okay. And would you agree that it would be beneficial to both the regulator and industry to have some regulatory certainty as to both factors to be involved in such a determination and the process that's allowed for operators?
I think that it could be beneficial for that. I would say that in doing so, I would strive to provide the division flexibility in what that is, because we don't necessarily always know what the opportunities are.
On line 121, you talk about adding a definition of beneficial use now risks creating internal inconsistencies. If the term beneficial use and beneficial purpose, those respective terms, are not defined in the rule, currently, how does providing a new definition create internal inconsistencies?
Well, I think I go on to in the follow-up portion of that to essentially to describe that.
So your assertion is, so it's not you're calling it an internal inconsistency on line 121, but it sounds like what you're actually saying is that you're concerned that the division's definition of beneficial use could conflict with a generally understood industry accepted definition of beneficial use. But I'm not trying to quibble about the word internal here, but that
I would
sounds like
say-
an external inconsistency to me.
I would say industry and regulatory.
Well, if it's inconsistent, wouldn't it benefit from a definition? I'll move on. Mr. Arthur, would you concede that it is possible in a rule to define a specific term for the limited purposes of the application of that rule?
I would say that just in experience in doing rulemaking, there's a lot of things to consider. So you put something in one rule and you say it's limited to that, but it can have, there's potential for there to be impacts and influences with other rules.
Okay. So is it your testimony that if we stated, for instance, this definition of beneficial use applies only to the implementation of 19.15.5 and 19.15.25, that despite such a clarification, we could have impacts on something else, like productive lease analysis or anything like that?
I can give you an example of
Okay.
where that has happened in the federal UIC program. The EPA, when I was there, defined what an underground source of drinking water is, and it was specific just to the UIC program. But today, the term USCWs are utilized in oil and gas and other types of projects that are not necessarily injection wells.
And your assertion is that incorporation or reference is problematic?
I'm not saying that it is problematic, but I'm saying you had something that was limited to one program, one regulation, and it ultimately influenced another. That can happen.
Okay, Mr. Arthur, I'm going to move on to page 9, starting on line 157 here. You talk about 90-day criteria. And I've highlighted some issues here, some language I'm going to ask you about. So when we talk about the 90-day production criteria as proposed in the presumption of no beneficial use, do you agree that we are mostly talking about wells that have been active and producing for an extended period of time?
Could you repeat the question?
Well, you're talking about issues with the 90-day criteria. So what I'm suggesting to you is that when you look at the presumption of no beneficial use, the way it's defined, that is intended to and structured to capture or address wells that are already well into their productive lifespan. We're talking about wells that have already been online for quite a while. Do you agree with that general presumption?
Can you show me in the proposed rule where it states that?
You're talking in your testimony about, I don't have the red line up right now, but I think it's fair to say that you are referring to the 90-day criteria.
Yes.
So I'm asking you about the implication of that structure, which you are testifying about. So I think it's fair to ask, Just to clarify.
And you're
like-
asking if I'm saying that this is limited to long life wells, and I don't see in the regulations where it says that. So,
Mhm.
but I think that's, that's probably what we're thinking here, but maybe, it doesn't, I don't see in the proposed rules where it limits to that.
Thank you. Thank you. That's where we wanted to get to. That's where I wanted to get to. That's the distinction I'm trying to make. Would you agree if we said the intent is not to capture wells that just came on 10 days ago and are being productive? That should not be the intent of this provision.
It shouldn't be, but it could be.
Well, we'll move on and handle that later. But so for mostly, we're talking about wells that have already been producing for quite a while. Thank you for that. The reason I'm asking you that is because you talk about lack of takeaway capacity. And so as this provision applies mostly to wells that have been in production for extended periods of time, I want to ask you if you're aware that natural gas takeaway is required in part by 19.15.27, the natural gas waste rule for active wells. Do you agree that there's a gas capture requirement and that wells have to have natural gas takeaway already?
Are you suggesting so if you have an oil well, so you're not flaring or venting? So correct.
Very generally correct. Yes, there's obviously more nuance in that. I'm just asking you if you're aware that there's a requirement to capture gas and to have takeaway capacity for producing oil and gas wells.
Yes, but if something happens with that could impact the well's operational capability, or wells.
Okay, and the concern that you're highlighting here is that you're suggesting that takeaway issues could result in a well being shut down 3/4 of the time.
It's possible.
Okay. In that
Could be any number of things, takeaway, whatever.
Right. Well, I'm just asking you about takeaway right now, but in that situation, and you've reviewed the petition, you said you reviewed the petition, revised petition in detail. Do you agree that that's a situation in which the operator could come in and explain to the division that the presumption of no beneficial use should not apply because they've been shut in by some takeaway capacity issue or other force majeure? Do you agree with that?
I think they could do that.
Okay, thank you. So I want to ask you, you also talk about strategic deferrals. And when in 161 here, line 161, when you talk about strategic deferrals, are you talking about placing wells in, in shut-in in some form of shut-in status while you talk about infrastructure upgrades, recompletions. Could that be applicable to things like an EOR or other types of projects?
Could be.
Okay. Do you agree that there is already a mechanism in OCD rule allowing for approved temporary abandonment of wells for all of those types of situations that you're outlining in this section?
The existing rules for temporary abandonment, yes.
Okay. And would you agree that, or would you be surprised to hear that there's over 550 wells currently in approved temporary abandonment status in New Mexico?
No.
And would you be surprised to hear that there are currently about 265 wells in expired temporary abandonment in New Mexico?
I don't know. It doesn't necessarily surprise me. If they're under expired temporary abandonment, is the division taking action to address those?
Well, I'm not asking you about the implication of the expired. I'm just I'm asking you, my questions are whether you're aware of the over 800 wells that have gone through that are currently in some part of the process of having gone through a temporary abandonment approval. So it sounds like you're not surprised by that and it's consistent with your understanding of the rule.
Yes,
Thank you. Under the current petition, temporary abandonment will remain a viable option for operators in these situations that you're outlining here, correct?
there's still a temporary abandonment option.
Thank you. Are you familiar with the presentation by OCD that responding to well inactivity only after 12 months of inactivity has an effective result of adding wells to OCD's orphan plugging program?
I have seen a lot of the testimony here, and it seems like that I could recall that vaguely, but if you wanted to pull the slide up for that, that would be helpful.
I'm just going to move on to another question, not to belabor that. I'm just asking about your familiarity with the, and again, it's a presentation. Would you dispute that over time, the Oil Conservation Division has obtained plugging authority for wells that were not plugged by their registered operator?
Yes.
You would dispute that?
Oh, no, I would
sorry.
agree that, yes.
I may have mumbled, sorry. I'm not trying to trick you. So, okay, so we agree that OCD has obtained plugging authority. And have you heard a reference to OCD Exhibit 17, the Master Orphan spreadsheet?
Yes.
Okay. And do you dispute that OCD has verified the existence of OCD plugging authority for over 1,800 wells?
That number sounds what I recall.
Okay. Would it be consistent with your understanding that many of the reference plugging orders came about under the existing requirement, the existing rules that operators must plug wells within 90 days after 12 months of inactivity?
Could you repeat the question again?
Yeah. Is it consistent with your understanding of the record and the review of the materials in this case that the plugging orders associated with those 1,800 wells that I mentioned, many of those came about under the existing rules?
Yes.
Okay. And those rules are that an operator has to it's a combination of 19.15.5 and 19.15.25. The combination of those rules stands for the proposition that an operator must plug their wells within 90 days after 12 months of inactivity.
I believe that's correct.
Okay. So under the existing rule, OCD has determined it's necessary to obtain numerous plugging orders for hundreds of wells. Despite those concerns that the division and the petitioners have put forward in this hearing, and that I've asked you about, and the related enforcement on over 1,800 wells, you propose to extend the inactivity criteria from 1 year to 3 years. Do you agree?
Could you refer me to the?
Let me ask it another way. I'll drop the preface. You propose to extend the defined inactivity period requiring plugging of a well from 12 months to 36 months, or I believe in your testimony, you say 3 years. Do you agree?
Can you show me that?
I'm asking you about your testimony. Is that your proposal?
I would like to see my testimony, so where you're referring to that. It sounds correct, but I want to see it. Sorry, I don't have every single thing memorized.
Thank you. I actually happen to have that one up. I was not anticipating that this would be a source of concern. So I'm going to refer you to line 164 of your testimony. The 12-month timeframe to determine cumulative production days and production volume should be extended to multiple years, at least 3 years.
Yes,
Okay, so your proposal is to go from 1 year of inactivity to 3 years of inactivity. I'm going to move on. You then go on to state that, starting in line 166, that if the 90-day criteria are retained, I recommend using consecutive 5-year periods to determine cumulative production days and production volume.
correct.
Okay, so if we include the day component, your suggestion is that ultimately that OCD would not be able to enforce a timely plugging of a well until after 5 years had elapsed. Is that correct?
Well, that aligns with the 5-year TA status. So as opposed to, going back in time, 5 years as opposed to 1 year or 90 days or whatever.
Well, I get maybe that's the source of the confusion here, because the section starting on line 156 is saying you have a recommendation to reject or revise the 90-day criteria. The 90-day criteria is proposed as one of the 2 criteria which would establish a presumption of no beneficial use for very low producing wells. So what does that have to do with TA? I am concerned with using up my time. I thought I was going to be moving a little more quickly, so I'll move on. Ms.
You have 5 minutes.
I have 5 minutes. All right. I'm going to move on to another topic, Mr. Arthur. So we've talked about, or you in your direct testimony at numerous places talk about concern with the 90-day criteria, which is, as I said, one of the 2 components of the presumption of no beneficial use. There's 90 days and there's 90 BOE. You don't seem to discuss any concerns with the production threshold of 90 BOE. So I would submit, could we simply address your concerns by striking the 90-day criteria and just relying for the presumption of no beneficial use on a production threshold of 90 BOE in the prior 12 months?
That if it was less than 90 barrels BOE over a 12-month period, that would be considered no beneficial use.
That would establish a presumption of no beneficial use, correct? Yeah.
I'm not sure I could say that either.
Did you at any point during your direct testimony analyze or reference the 90 BOE criteria? I'm going to move on. Point you to page 18, line 350. This section talks about a new isolation device requirement. You outline some concerns about impacts to the wellbore related to that device. When you wrote this, did you understand that that isolation device was already required generally by the Bureau of Land Management?
I do understand that BLM will do that for wells and federal.
Okay. Let's see, 370, you talk about safety concerns associated with leaving bridge plugs or packers in place for multi-year periods. Would you concede that in the absence of the placement of that device, the wellbore would already be exposed to the same environment?
You say that again?
Whether or not you're talking about mechanical isolation devices that are subject to degradation due to corrosion, temperature cycling, et cetera, et cetera. If that device is not in place, the wellbore, the unplugged wellbore would nevertheless be subject to those same forces, correct?
The wellbore certainly could be, but you know, if you've ever had to fish a cast iron bridge plug out of a well that's been in there for a long time, it can be a challenge. And so having those in there for extended periods can sometimes be an issue, but it depends on the well and the corrosivity and other things.
All right, I want to move along to page 27, line 527. The highlighted section here, you state Wilkes' proposal abandons the existing risk-based financial assurance requirements for individual bondings for such active wells. You are suggesting here, you wrote here that the existing rule is risk-based. Is it your assertion that the petition with the additional category and the information presented at this hearing is less risk-based than the existing rule?
I would say, I mean, it's just a flat for everything, a flat criteria, $150,000 per well.
And by that, you're referring to the proposed definition of marginal wells, which you did not use in preparation of your direct testimony. So the $150,000 single well FA applies to wells that fall under 1,000 BOE or less, or 180 days or less, which we've heard testimony amounts to about 2.7 BOE per day, or BOE, yeah, BOE average per day. Do you agree that that is a fraction of the threshold used to define stripper wells or marginal wells as you used in preparation of your testimony?
Sorry, the way you're asking your questions can be very confusing, so I'm going to ask you to.
I'm not trying to trick you, Mr. Arthur. I admit I'm a little confused by the testimony. So you're saying that, okay. You use the definition to generally accept the definition of marginal wells. So you're saying what you just testified to is that the $150,000 is broadly applicable. It's applicable across the board, and that was your criticism of it. Is that fair?
That's broadly applicable.
I'm trying to do that. Yeah. One moment, Madam Hearing Officer. Mr. Arthur, you are a certified petroleum geologist, correct?
Correct.
And you act as a contractor for various different entities. Is that correct? Are you required to, or do you, as a matter of practice, carry any practice insurance?
Yes.
Okay. Do you have any experience procuring either plugging or remediation, environmental remediation contract services?
Have I been retained to do plugging
No,
or restoration.
procuring, yeah. So have you ever worked to procure either plugging or remediation services from another entity?
We've hired contractors to help with that, yes. If
Okay.
that's what you're talking about.
When you did that, how much insurance did you make your contractors carry?
So there's a variety of different types of insurance from, you know, I don't remember the specific levels that are in our contracts or that we have. I mean, there's, like they said, general liability, this, that, and the other. I mean,
Please wrap up, Mr. Tremaine.
Mr. Arthur, did you know that you were to oppose the petition before you drafted your direct testimony?
I wasn't asked or contracted to, or hired, nor would I to, we want to hire you to come up with this opinion. I don't do that.
And you've been engaged in prior rulemakings in the past, correct? I believe you testified to that.
Yes.
Is it normal practice for you to engage in a rulemaking without ever having talked to the regulator?
So once, and I'm, again, not an attorney, and I don't know all the stuff, but as just in, like, I would look at that if I'm retained as an expert. I don't generally go talk to the other side, you know, in there. That would, you know, just, you know, when I do expert witness testimony or whatever, which is what I'm doing now. So would I, if I was retained by Numoga or someone to say, could you help us work with an agency on new rules? I've done that too. That's different than this.
Thank you. Thank you, Mr. Arthur. I'll pass the witness, and apologies to the commission. I thought I was going to be 20 minutes.
All right. Thank you so much. Mr. Moore, do you have any questions of Mr. Arthur?
I do have some questions. Thank you, Madam Hearing Officer. Good morning, Mr. Arthur. My name is Richard Moore. I represent the Commissioner of Public Lands and the New Mexico State Land Office in these proceedings. Thank you for your testimony yesterday and today. It's my understanding that you oppose the applicant's proposed inclusion of a definition for expired temporary abandonment or expired temporary abandonment status. Is that correct?
The way that it's prepared right now, yes.
And are you familiar with the OCD's permitting web portal?
I'm familiar with it. I don't use it. I usually will have other people on my team utilize it.
Are you aware that on the OCD's web portal, expired temporary abandonment is a status that is applied to wells permitted by the OCD?
I
I have not looked at that on the web portal.
I'll just share my screen quickly. So I'm just going to, if you can see my screen, would you agree that expired temporary abandonment, if you can see it, is one of the statuses available in the drop-down menu on the web portal?
Yes.
Would you agree that it would promote transparency and clarity for the public on this public-facing web portal for there to be a definition for a status that is applied to wells viewable on the portal?
It could be.
But you don't support the inclusion, or you don't at least support the proposed definition for expired temporary abandonment. Is that correct?
I have concerns with it.
Is
Fair
there
play.
oh, sorry. Is there a definition that you would support for expired temporary abandonment?
I think that I would say that there could be. I don't have a proposed one. I think that that's something also that NMOGA would be more than open to working with the OCC and SLO, et cetera, on working through.
But you haven't proposed a definition for expired temporary
I have not.
abandonment. You expressed some concerns with the language of complies or no longer complies and expired temporary abandonment. Would a definition that states that expired temporary abandonment means a well that has been approved for temporary abandonment status, but no longer under the applicable regulation, but no longer meets the definition of approved temporary abandonment?
I'm sorry. You're at. I mean, at a high level, that sounds reasonable, but like, what I hate to. I don't want to come up with answers just off the cuff here. So.
I'll share my screen one more time. This is applicant's exhibit 72 with the proposed changes. Do you agree that the proposed language includes defines an expired temporary abandonment as meaning the status of a well that is inactive and that has been approved for TA status but no longer complies with those regulations?
Yes.
And are you aware of the definition of an inactive well under the current regulations?
Could you show me that? I don't have that.
It's here on the I subpart 4. You can make that a little larger as well if you.
It's that's okay. Yep, that sounds applicable.
And would you agree that under OCD regulations as currently written under 1915 25.8, which I will go to, an operator must either plug and abandon a well or place the well in approved temporary abandonment within 90 days of a 60-day period following suspension of drilling operations, a determination that the well is no longer usable for beneficial purposes, or a period of 1 year in which the well has been continuously inactive.
Yes.
Did you hear? I know you said that you've heard some of the other testimony in this case. Did you hear Ms. Mark's testimony that on the OCD permitting web portal, there's not a status of inactive that is applied to wells?
I did not hear that testimony.
I know you mentioned that you aren't particularly familiar, but would you do you see in this drop down list on the web portal, is there a status of inactive that applies to wells permitted by the OCD?
There's not one on that drop down list.
Would you agree that it would promote clarity? I'll go back to the proposed definition. Sorry, I went a little too far. To remove the reference of inactive from the proposed definition of expired temporary abandonment, to simply include the definition as a well that has been approved for temporary abandonment status in accordance with the regulation, but no longer complies with those regulations.
I feel like we're proposing like different options of modified rulemaking, and I'm not, I hate answering questions in that fashion. I don't want to be speculating in the answers that I provide.
Understood. I believe that's all the questions I have. Thank you for your time.
Thank you.
Thank you, Mr. Moore. Is Ms. Nanasi on the platform? No. Mr. Maxwell?
Your Honor, no questions. Thank you very much.
Thank you, Mr. Maxwell. Mr. Rankin?
No questions. Thank you, Madam Hearing Officer.
All right, Mr. Sayer? No. Thank you. And Mr. Cloutier?
Thank you, Madam Hearing Officer. Good morning, Mr. Arthur. I've got questions about a couple aspects of the rulemaking that really haven't been focused on much in the live hearings here. But before that, could you explain to me whether you believe that a bonding system, which would require a well that produced 999 barrels of oil equivalent over 179 days over a 12-month period, should be bonded for $150,000. But if the next month, the trailing month average figures became 180 days and 1,000 BOE, it would not need to be bonded. Is that a risk-based bonding system in your mind?
Those kinds of things happen with oil and gas wells because they're not, they're producing from nature, but it doesn't appear to be a risk-based approach.
Thank you. If I think Mr. Everhart has, Ms. Tripp's got some family matters. If Mr. Everhart, I'm going to look at slide 37, which was page 38 of your PDF. Please, Mr. Everhart. And this is applicants' proposed changes to 19.15.8.9, and I'd like to focus on the red line change there at the end of paragraph A. Are you with me?
Yes.
First of all, in working with regulators and having been regulated, what do you read the word proposed to modify in this sentence?
Drilling and possibly acquisition, it's unclear.
Okay. And what is an operator not permitted to proceed with until it, quote, has furnished the required financial assurance?
Proposed drilling or acquisition.
All right. What comment would you have about the regulation and its workability if proposed is intended to modify the word acquisition?
That's really tough because, that means you're going to have bonding to pursue acquiring assets. So if you're a new operator to the state or an existing operator that may be acquiring assets from another operator, you'd have to have bonding in place even for a proposed acquisition.
Are there situations where assets may be for sale, or frankly, a company may be for sale where they're in the industry where there's more than one potential acquiring entity?
Yes.
And I think on the next page, you express some concern about, sorry, I flipped past it. You say, and I quote, unnecessarily exponentially increase the bonding required. Does that concern have anything to do with the word acquisition in the proposed rulemaking?
Certainly, and it can get complicated in in what you reference there, because like we're helping an operator right now sell some assets, and so they have a data room up and multiple people looking at it. But with these, even for proposed acquisition, you'd have to have bonding, which means you'd have to have multiple people with bonding without even proceeding with completing the acquisition and coming to the state to get authorization.
When would it be appropriate for the state of New Mexico to want to require bonding from a new operator or potential new operator?
When they have those assets and they approve them to be an operator.
Thank you, Mr. Arthur. Appreciate that. If we could move to what was slide 55, page 56 of that PDF, please. That's the wrong page. I'm sorry. I'm looking for the changes to 1915. 9, well, the waste prevention. I'm sorry. Yeah, it's page 55 of the PDF. You with me, Mr. Arthur?
Yep, I see it.
Okay. And subsection A, as I appreciate it, defines what it is to be an operator in good standing in the state of New Mexico, correct?
Yes.
Could you explain to the commission your concern with the change to subsection A4 of that rule?
Well, this is essentially what I discussed yesterday, but it one removes the buffer that was there, but so you could have an operator with one violation and they're no longer in regulatory compliance.
And that regulation refers to the financial assurances rulemaking in sub 4?
Correct.
And currently the regulation requires more than one violation, correct?
Correct.
With a fluctuating bond, well, let me strike that. With a proposal that bonding on a well be contingent on production days and production volumes that can vary over time, would it be a good idea, for instance, for the state of New Mexico to have a policy where an operator of 250 wells fails to realize that one of his wells has slipped into marginal status, fails to bond it timely, and then has its authority to operate all of its wells pulled?
That I'd say that example aligns with what's here because they would no longer be an operator in good standing.
And what happens to the wells in that scenario?
They can't be produced.
Is anyone allowed to go put hands on that well
Nope.
for any reason?
Nope.
What happens if there's an emergency?
Bad things can happen.
Same question on the new proposed sub A5. What regulation is that referring to that currently meets the requirements of?
The flaring and venting.
Right. And I think here and I don't know if it's in the proposed rulemaking, but it should read 19.15.27.8 rather than A8.
Oh,
Ms. Fox is even nodding at me, so we agree on one thing.
yeah. It's right over to the, it's correct over to the left, but not in the.
Right. Okay. And do you have an understanding of what 8.A of subpart 27 does?
I think so. We talked about it here just a little bit ago.
Prohibits venting and flaring, correct? And then you referenced in your testimony with Mr. Tremaine, subparts B, C, and D, which permit venting and flaring in certain narrow circumstances during drilling, during completion, and during operations, correct?
Correct.
Do you have any concern about isolating the amendment here to only subpart A of, subparagraph A of 27.8?
It could make this very challenging because, again, an operator with 250 wells has one well that gets caught up in this, and it's the same situation we talked about before.
And in the circumstance I mentioned just in A, any venting and flaring is prohibited under A, correct?
Correct.
B through D permit some venting and flaring under particular circumstances, correct?
That's right.
Is it a good idea for the state of New Mexico in our hypothetical 250 operator status to revoke operator status based on a single violation of a venting and flaring rule?
It doesn't sound like a very good plan to me, and that could result in a lot of negatives and without any, without it being some significant positive.
Sounds like we're imposing the death penalty for a single venting and flaring violation is the proposal, correct?
That's about right.
All right. You were asked some questions about the LFC report, Mr. Arthur. Do you know what information the LFC sought from industry prior to preparing that report?
I don't know that.
Okay. Do you know if the LFC sought any information from any industry participant or trade association prior to preparing that report?
I'm not aware that that happened.
Do you know if industry, when it found out about the LFC process, was refused to provide information to the LFC prior to that report?
I am not or was not aware of that.
Okay. Thank you, Mr. Arthur. I appreciate your testimony and thank you for your time today.
Thank you, Mr. Cloutier. Mr. Suazo, do you have redirect?
I do, Madam Hearing Officer. Can we take a 5-minute break?
We can. Let's come back at 10:25. That's a 9-minute break. Let's come back from the break, please. All right, we will turn now to commission questioning of, I'm sorry. Oh, Mr. Swazo, redirect. Very sorry.
Thank you, Madam Hearing Officer. Mr. Arthur, I just have a few questions in light of some of the questions that you were asked on cross-examination. Let's start with some of the questions that counsel for applicants asked you. And, I think there's some things I want to clarify just because, in this type of forum, unlike a courtroom, there's kind of a lot of preface to the question. So I want to make sure that we kind of focus in on what the subject was so that you can more clearly answer, some of the things that the other parties were getting at. Now, let's start with Welk's questioning of you by Mr. Tisdale. Applicants took issue with the absence of a list of materials in your direct testimony. Do you remember that?
Yes,
Okay, and instead of a list, you actually included the list of all the sources that you used in your testimony as footnotes, correct?
yes,
Okay. And you used those, I counted 36 citations throughout your direct testimony, correct?
sounds about right.
Okay. Let's talk about your experience with EPA's data projects on high-risk wells to, as they relate to Welk's proposals. Can you tell the commission a bit more about how you helped the EPA to develop a program to assess risk-based data?
So and we're talking about what I mentioned with DOE, DOI, EPA.
Yes, sir.
So we looked at the age of the well, the depth of the well, water quality characteristics, production history of the well, casing details, a variety of different things that were considered. I would say I don't know the exact number, but over 100 details that we talked about in looking at trying to characterize those things. And we had USGS input as well in that process.
And did I understand correctly that you referenced that EPA methodology as a means that could improve applicants' proposals?
I think so.
And is that because that would make them more of a risk-based approach?
That was what DOE, DOI, and EPA were trying to do, is to address those high-risk wells.
Okay. And let's move on to some of the questions from OCD's counsel. You discussed various definitions in your testimony with respect to marginal and stripper wells in other states for comparative purposes, correct?
Yes.
Okay. And you compared those varying definitions to the proposed definition of marginal well that's at issue in this proceeding, correct?
Correct.
Objection leading. Questions?
All right, Mr. Swazo, just rephrase it.
Why did you use those other definitions from other jurisdictions? Was it for comparison?
To try to compare what other states are doing or have done to what is being proposed.
And why do you believe that comparison is important for the commission to consider?
So looking at what other states are doing is, I think is important to understand.
Why?
It gives some basis of what other states have already done, because if you think of this as well, as many of the operators out there don't operate in only one state, they're operating in multiple states. So
And,
having that understanding, the comparison can be quite helpful, in my opinion.
and is it accurate that many other jurisdictions do not define marginal or stripper wells?
That's correct.
Okay. And so when OCD asked you whether or not you used the proposed definition of marginal wells that is at issue in this proceeding, that's incorrect. Is that right? And that's incorrect because you were comparing it to other jurisdictions.
Correct. That's what I was trying to do. And the questioning there was very confusing.
Okay. And so you did not provide your own definition of marginal or stripper. You just compared what applicants were proposing to other jurisdictions. Is that right?
Yes.
Okay. You were asked about lease management on Cross, and you discussed how a well producing 0.25 BOE a day can help maintain a lease while the operator does things such as raising capital for other investment projects, correct?
Yes.
Okay. Do you have any more examples for how producing wells, even if in small quantities, can allow more time for an operator to develop other zones or opportunities?
So having that, certainly, in what you just said, geology is complex, reservoirs are complex, and trying to assess that takes time. And being able to have even those low production periods and wells, just like Oxy showed yesterday, can be critical to, you don't want to lose leasehold. You don't want to, you want to do that. So it can be imperative to be able to allow future bigger projects to go on.
And so just so I understand, as a non-oil and gas operator, essentially these small production volume wells can allow operators to buy time so they can continue to expand their operations?
Well, buy time and also generate income,
Okay.
even if it's small and less desirable.
And by that, do you mean that they generate income that can show that they can develop other projects, or how do they think about it?
Well, I would say in multiple instances, but if you can produce, if you got wells that are producing a couple of barrels a day, I know many that do that, and that's a lot of their production is only, 1 or 2 or 5 barrels a day, and they produce that oil and sell it and generate income to offset operational costs and so forth, while they're looking at other options maybe.
Now, OCD's counsel asked you about the presumption of no beneficial use. Is that accurate?
Yes.
Okay. And let's talk about that 90-day criteria. That is the defined term that you used to define both the 90 BOE and at least the 90 days of production over a 1-year period, correct?
Correct.
Okay. And it was the shorthand that you used, so you didn't have to keep reiterating those 2 elements, correct?
Objection, leading.
Mr. Swazo, you really are doing most of the testifying here.
Did you use shorthand to refer to those 2 elements?
I was trying to look at the 90-day criteria as opposed to going in 90 days, 90 barrels. I probably could have done that, but I was assuming that was really meaning both.
And was that an expressly defined term in your testimony?
My testimony does talk about the 90-day and 90 barrel.
Okay. So would you then say the OCD's claim that you eliminated the volumetric threshold is inaccurate?
Yes.
Let's talk about OCD's questions related to your recommendation about 5 years being a good time frame for assessing beneficial use. Can you explain to the commission how things like capital allocation cycles might impact timeframes with respect to wells?
Operating oil and gas assets, just like anything, can be very complicated by getting, you may have to go raise money to do projects, and in doing that, you may be getting investors that could take a significant amount of time. Even with some of the bigger companies, they may not they may have a process. Like if you're, in my experience, if you're doing stuff with some of the, even the majors, it takes forever to get through that, scenario of working through all their management teams to get them to agree to, to spend that capital. So it could be a variety of different ways, but I think what we see a lot and what I've probably most experience with is people trying to raise money to do those upgrades or projects or acquisitions or whatever.
Okay. Do you recall Mr. Tremaine asking you about the presumption of no beneficial use and when it's triggered?
Yes.
Do you remember his question about operators having the opportunity to refute that presumption?
Yes.
Is temporary abandonment implicated by that presumption?
Yes.
And is it your understanding that if the presumption is not refuted, that then the well is required to be permanently plugged?
Correct.
Do you recall being asked about the difference in cost between horizontal wells and vertical wells?
I remember the discussion that he had there. Yes.
Okay. And what was the purpose of you? Well, let me rephrase that. Was it your testimony that the proposals are less risk-based, the proposals by the applicant, because they removed the inquiry into things like the depth of the well?
Yes.
Let's move on to temporary abandonment. If a well is classified as being in expired temporary abandonment, do any of those wells stay classified as expired and temporarily abandoned, even if paperwork is submitted to OCD, to your knowledge?
I would say until OCD approves that, it would remain that in that, and even if you have submitted.
Okay. So what you're saying is it can retain that status while the division is potentially reviewing paperwork.
Correct.
Okay. Are you aware of any numbers with respect to how many applications for temporary abandonment OCD has received?
I'm not sure.
Are you aware whether OCD's online lists for tracking active and inactive wells are up to date and current?
I don't know that.
I believe that Mr. Tremaine asked you whether you were aware that when OCD plugs wells, they also plug other wells in the vicinity. Is that correct?
He said that, and I believe they try to do that.
And you agreed with that approach, correct?
Yes.
Do you know whether the average costs that OCD claims it incurs for plugging wells includes the costs for the wells in the vicinity?
I have not tried to specifically analyze all those details.
Do you know whether that information was in the LFC report?
Was not.
Have you seen OCD provide that information in this proceeding?
No.
No further questions, Madam Hearing Officer. Thank you, Mr. Arthur.
Thank you, Mr. Suazo. Commissioner Ampoma, do you have questions of Mr. Arthur?
Yes, I do. Mr. Arthur, thanks so much for your testimony today. I just want to be sure that you are the chief witness for Nimoga. Is that correct?
That's correct.
Okay. Yeah, Mr. Suazo, if possible, you can bring up the slides. So I will just walk through that to ask some few questions.
Sure, give us just a second.
Thank you. Yeah, let's start from slide number 8. And that is the scope of direct testimony. Yeah, I'll start with D. So you're saying that the new definition of marginal wells as proposed by the applicants, you went on to say more stringent than federal and other states. Do you still stand by this assessment?
Yes. And it's included in some of the examples that I showed.
Exactly. Yeah, we'll get to that. But I just wanted to dive in a little bit more deeper into that. Can you confirm to the commission the definition of marginal wells as proposed by US EPA?
I believe it's 15 barrels a day, BOE.
So if you compare that to what, so in a year, how much barrels are we talking about here?
I don't have a calculator in front of me. I didn't look at the annual aspect of that.
So let's say if we multiply 15 by 365, we're looking at over 5,000 barrels a day. Is that correct?
Sounds about right.
So how does that compare to 1,000 or even the 750 BOE that we are still discussing here at the hearing?
I don't understand your question.
So you're saying that the applicant, their definition of marginal wells is more stringent than federal and other states. So I'm just focusing on the federal, and we're just doing the math. The federal is proposing that before a well can be classified as a marginal well, it has to produce about 5,000 barrels of oil in a year. But the applicant is looking at 1,000, and even they are willing to go down to about 750. So how stringent is this proposal to that proposed by US EPA?
Commissioner, if we could go to the definition where we have for marginal wells here, that would be helpful.
Yeah, your lawyer can do that. I do not pay the controls.
Just to clarify, Commissioner Ampoma, you're talking about EPA's definition for marginal?
No, maybe you can ask your witness. He's asking, he wants to see marginal. I don't know which definition he wants to see. So maybe you can ask him for that.
Mr. Arthur, which definition are you looking for? I can pull it up in your testimony.
I was trying to look at what the proposed definition of marginal wells in the new regulations is.
search for the slide since that's so accessible. I don't think I saw the exact definition in Mr. Atte's slides. But I can read to you what OCD presented to us. So they're saying that marginal well means an oil or gas well that produce less than 180 days and less than 1,000 barrels of oil equivalent within a conservative 12 months period.
Correct.
So do you want me to repeat my question again, or?
So the EPA definition, the other state definitions don't include a specific threshold of number of days produced is one. So there are differences. The total barrel BOE is what's being proposed here of 1,000 or 750 is less for that definition of a marginal well. So being able to specifically say it's more stringent, it's a combination of those two factors is what I would say. But I think that having something that was more in the 750 BOE and being more flexible on that 180 days, just as the IPA and M asked about in that, how those things can change, I think would be reasonable.
So is this something that NIMOGA is going to provide their definition to the commission for consideration?
I don't know that, but I think that NIMOGA is very open to working with the commission on that.
Yeah, and you are the chief witness, so I'm asking you, probably you are going to tell the commission, or is it the lawyers going to tell the commission?
It would be them to tell the commission
Okay.
on that.
Thank you. Let's go to slide number 14. So you recommended to the commission that we should reject adding the new definition. And then you say that in the event that the commission decides to proceed with that, my question is, are you okay, or is NIMOGA okay if the commission strike speculative purposes?
If they strike what now?
Speculative purposes that was added to the original beneficial use or purpose.
I think I would have a lot less problems if the speculative purposes text in there was stricken.
Let's go to slide number 17. So you are recommending to the commission that we should reject the 90-day criteria. Now I want to ask you, have you listened to the testimony that the applicant and even OCD is open to have some exceptions? Have you had a chance to listen to that testimony? And do you have any comment on that?
I was not able to hear that testimony. But that's
okay. Then I'll read.
I think NIMOGA is certainly open to discussing these things with the commission.
Okay. So will the lawyers be the ones that will review and then provide some feedback to the commission?
I believe so.
Okay. Thank you. But let me ask you, do you have any exceptions that you want to propose to the commission?
I have not tried to develop that specifically yet, other than things to consider. So I haven't tried to make specific recommendations of this, but other than some of the things that I include in here, like reducing speculative, et cetera.
Okay. Let's go to slide number 31. So here you're saying that the marginal well should not be defined, but if it is, must be grounded in operational and economic context, considering leasehold strategy, reservoir management needs, and cash flow projections or Labstrat thresholds. And then you go to the second one saying, if it must be defined, then the definition should incorporate flexibility and allow for a case-by-case economic assessment, like the EPA production-based criteria and on and on. On this one, can you explain a little bit on the case-by-case? Because I'm a little bit confused about, I feel like a rule has to be clear and direct to avoid any confusion. So I'm a little bit confused by, the recommendation that we should do case by case economic assessment. If you can speak a little bit to that.
I think that I can certainly understand, having the desire of a rule to be clear, but I would say that in my experience working with multiple state oil and gas agencies, BLM, DOE, et cetera, it's tough because we're dealing with very complex projects and so forth. So it's not always clear. This isn't like, having a rule that there's one way to do it and it's very clear and it's the same every time. And in this case, it can be very complicated for leasehold and a lot of the different things that we talk about here. So my encouragement is to have flexibility and consider these things on an overall case. And that's why you have, technical people with those backgrounds that work for the OCD so that they can do those evaluations and understand it.
Don't you believe that has contributed to the loopholes and even the numerous orphan wells that we have in the state of New Mexico and in the country?
So keep in mind, if we look at orphan wells in the country, a lot of the wells were orphaned before there was even regulations for wells. And, companies that went out of business in the, pre-1900s, the 1920s and so forth. So if you look at even the rules and regulations of various oil and gas agencies, the existence of API, which they weren't there until I think 1918. But so I'm not sure that loopholes is the sole reason for that. I mean, a lot of it is just that's what happened and how oil and gas used to be developed. It was just people going out and drilling wells and producing them and moving on. But there's also been major crashes, like I mentioned yesterday, like Penn Square Bank, or during COVID with oil going to minus $47 a barrel. But what I will also say, and I agree 100% with, that there certainly are bad actors. There can be bad actors. There can be people that are non-compliant. I worked in enforcement when I was at the EPA in the 80s and helped with the first criminal indictment under the Safe Drinking Water Act. So there certainly are, and there's certainly people that do try to cheat, that do try to find loopholes that exist. That doesn't mean that you can broadly characterize that or that, it's just all small operators are bad, or all operators producing low production wells are bad, or whatever it is. But I think that having that flexibility and having the staff that the state has can help assess those loopholes so that that doesn't occur.
Thank you, sir. Please, let's go to slide number 33. So in your first sentence, you're saying that marginally producing wells in New Mexico collectively contribute a meaningful share of the national production. Do you have the numbers to back this up?
I believe that later in this that I included data for the state of New Mexico for marginal wells that was published from I think a 2004 report.
And then you say that on your point 3, huge financial losses and repercussions, including tax, lost tax revenue. Did you do the analysis for this too?
Well, later in one of the slides, I noted that that in New Mexico, the industry provides, I think, it's $7.8 billion to the state, and if you look at the percentages of marginal wells from that, that contribution would be over $1 billion.
Commissioner or Madam Hearing Officer, just to clarify, that's on page 38 of his testimony, and you can see at the top of the slide where there's greater detail in the direct testimony with respect to what's on the slide.
Thank you. I appreciate that. I wanted to see that reference. So thank you. Thank you. Let's go to slide number 38. Yeah, number 38. Yeah. So IPNM counsel touched on this a little bit, and he stressed that there has not been a lot of discussion on this provision. And he did a good job, going back and forth with you on this. But I want to pick it up on that a little bit. So the red line here on the top, we're saying that the division shall not approve and the operator shall not proceed with any proposed drilling or acquisition until the operator has finished the required financial assurance. So you had a lot of issues with that, but my question is this provision not to reduce the state's risk of wells passed on to operators, if not vetted, will not be able to plug low producing wells, which in turn becomes an orphan and then becomes a responsibility of OCD?
I think that is, I'm speculating that is likely what the goal of this is, but I think that there's unintended consequences, and just from this language confusion, and even looking at that orphan wells, what I haven't seen is just the ongoing statistics of those wells being orphaned, how OCD is, for instance, managing enforcement and compliance from operators to use the regulations and rules already in place to help try to avoid that.
I tried to do when the discussion was going on, I tried to check and see what OCC's response to that provision was. So I couldn't get that. But do you know if OCC also provided some feedback on this language?
I don't remember.
Okay, I will check that. I will check into that. But is NIMOGA going to propose any potential changes to this provision?
I don't know what they're planning to propose, sir. I do believe that they are open to working with the commission on on modified language, and this one, as was noted during that clarification, even would help this a lot.
Madam Hearing Officer, just to clarify, the proposals that NIMOGA has provided to date are typically contained in Mr. Sporich's testimony. He's just providing the technical assessment, and then the legal witness will actually provide language on certain proposals. Given what we learned over the hearing, there might be Namoga may be willing to provide more at a later time, but, given where we were at the inception of the hearing, we could provide limited recommendations and proposals, but we were not planning on doing that through this witness.
Thank you, Mr. Shan.
I appreciate that. So when I ask the question, yeah, you can just pass it on. I appreciate that. Please, let's go to slide number 39. I'm a little bit curious. So here we're talking about the blanket bond of 250,000. Is that correct for the active wells? Is that correct?
Well, starting with the 25,000 plus amount determined by depth and tiered with the blanket bond, yes.
Yeah, that one, you attribute that to the risk base for individual wells. But, so your bold letters here, I'm a little bit, maybe I do not understand, because you're saying that is unworkable, unnecessarily exponentially increase the bonding requirement for wells which pose the least type of risk and the most prevalent type in New Mexico. Are you referring to the proposed 250,000 blanket bond?
No, this would be the $150,000 individual bonds, proposed increases for active well financial assurance and so forth.
Okay. So then let's talk about the bond and the requirements that the applicant is willing to go down from 15% to 30%. Have you listened to that testimony?
I have not.
Okay. And do you believe that if, let's say, the 30% threshold is implemented instead of the 15%, would that help alleviate some of the concerns that you have here?
That would certainly be better.
Thank you. Let's go to slide number 40. So you've talked a lot about the amount that the plugin cost, that is being proposed as 150,000 per well. My question to you is, do you know the most expensive plugin performed by the industry in the recent years that you are aware of, that you can share with the commission? The most expensive plugin?
That was done by industry?
Yes.
I have I'm just trying to think of one that we plugged in the middle of the river, and that was over $1 million.
So the industry has plugged a well that is even up to like $1 million.
It was that was an exception, but yes.
Okay.
It was in the middle of a river. You had to
But it's still classified as onshore.
yes.
Okay. So you discussed about the risk-based analysis. Now, OCD and the applicant, I was with you on that. I thought that there has to be a risk base where the amount proposed for a bonding is tied to the debt, the age, and all of that. Now, OCD and the applicant proved that it's not really the major factor, especially for the wells that OCD plugs. What is your response to that?
So what I haven't seen from that is a provision to look at all those details and statistical analysis of the wells that they plug from those particular considering those particular details. So what we did see from the first OCD witness is where he showed those two wells that were near each other and that they had to delay based on an owl being in the wellhead, and one taking, I don't remember the specific days, but much longer than the other well. So obviously, I don't remember that he discussed costs for each of the two, but one appeared that it was cost significantly more than the other one. But I don't know. I haven't seen the details of what you're asking presented by OCD.
But you will agree that industry do have more numbers, more data points on well plugging probably than OCD. Would that be a fair assessment?
I would say that's correct. But like where industry is plugging, oftentimes, say, newer wells or wells that are not in such bad condition as some of the examples that OCD showed. So sometimes you guys get the worst of the worst, but sometimes not. So it just depends on that. But industry definitely has a lot of data on that, on what they've spent to plug wells. We worked with companies that have plugged, like one Diversified, they're plugging thousands of wells.
So one thing that I've not heard so far is let's say the 150,000, if industry is proposing a different number. So don't you believe that it would have been more prudent for NEMOGA to engage with the applicant, with OCD, to really come up with what you believe could be the best number?
I think I'm very supportive always of collaboration. So I don't know that what opportunity was there for that or whatever, but I think that would be a good path forward for all interested parties to work together on looking at that risk-based analysis, to look at how costs vary, by the type of well, the age of well, all those different things.
So let's go to slide number 44. And I'm just going to ask it, but if you do not have the answer, maybe Mr. Suazo might have a different witness to respond to that. Has NEMOGA quantified the impact of these proposals on its members?
I don't know that.
Yeah, so let's get to slide number 47. And this one is very important. Now, there is no clear blanket bonding for the marginal wells, other than more like you have to provide 150,000 for all the wells in one single instrument. Does NEMOGA has any thoughts on, because you touched on the proposal would require operators with incomplete blanket financial assurance requirements to provide an additional 150K for all of it. So I'm asking if there has been any discussion about a blanket bond for marginal wells.
I believe Mr. Emmerich is gonna talk about that.
Okay, thank you.
And Madam Hearing Officer and Commissioner Ampoma, I believe that IPNM's witness discusses some data on the overall impact to the industry based upon the proposal. So it's kind of all over the place given the number of witnesses. And, again, this witness was intended to kind of provide a criticism and recommendation on how it might be improved, but he is not in the position to speak for, NEMOGA's recommendations on some of these other issues that have evolved over the course of the proceeding.
Thank you. On slide 48. So I just want to ask if specifically you have done any analysis to disprove what OCD and then the applicant is saying, that the the depth is not really the driving factor of the wells that OCD plugs.
Depth can be a factor, but it can be, it's one factor. So it's, like some of the wells that OCD presented as examples have been there for a long time, had equipment or junk or whatever in the hole that they had to fish out, highly corroded. So it's, depth is certainly a factor, but it varies in different things. So for instance, in the San Juan Basin, a coal bed methane well that's 1,000 feet deep or 1,500 feet deep, and it's fresh water that's maybe not real corrosive. I mean, there's a number of things that go into that, sir.
Yeah, and as a petroleum engineer, I side with you until they proved me wrong. Yeah. Okay. Let me try to wrap up here. Yeah, so let's go to slide number 63. And this is also to the prohibition of transfer of non-compliant wells. I think I might have probably asked you about this one, so let me move on. I think I'm going to end here. So thank you so much, Mr. Atta, for your testimony. Thank you.
Thank you.
Thank you. Commissioner Bloom on the platform, do you have questions of Mr. Arthur?
Yes, Madam Hearing Officer, thank you. Mr. Arthur, good morning.
Good morning.
And I'm trying to remember if we might have crossed paths here at the OCC before. Did you work on the 2012 pit rule?
Yes.
That's what I thought. Okay. I remembered you once you get on the stand. All right. Mr. Arthur, I can't recall if you specifically got into this or not, but one question I did want to ask of Namoga, maybe someone else will address it later, but if the 180-day activity provision for marginal wells ultimately survives this process, should there be exceptions or carve-outs for things like a pipeline going down, i.e. there's a midstream or takeaway shutdown?
I think that would be very prudent, because just speaking from current historic knowledge and current knowledge, I'm working on a project that exactly that is the case right now, where a pipeline that in this case went under a river, ruptured, and it's been down for a while, which shut down all the production that was going to it.
Okay. Perhaps this could be a scenario where the operator would share the midstream provider's notification of shutdown with the OCD in these cases.
I think that would be a great idea.
Okay, thank you. Mr. Arthur, did you recommend that the OCC consider a tiered approach to bonding?
Yes. Did
you provide testimony to us of what this would look like?
I have not. I've not done any of the proposal stuff. I think some of the other witnesses will get into that.
Okay. Again, I've talked about this before with other witnesses, but I think we're getting some recommendations, but they aren't fleshed out. So in these, scenarios where you're making recommendations, but not saying why they'd be superior to what's already been presented, or what the specifics would look like and how the commission would justify taking these sorts of actions. You know, what's the path forward? Do you know?
You know, I don't specifically know, but I would just say based on experience in this, you know, when I've worked on a contract basis to other state oil and gas agencies in rural development. And what I found that worked real well was not getting in a giant hurry and doing working sessions with interested parties. And I think that the applicants have done some of that, but I think that it would be helpful to engage NUMOGA and NUMOGA's members as well as IPA&M and perhaps others.
Okay. Yeah, so perhaps NUMOGA and other parties could present how they would see this working out between now and when we meet to deliberate at some future point.
I think my impression is that I think NUMOGA would, and I can't speak for NUMOGA, I'm giving you my impression is that, but my impression is that I believe that NUMOGA would be open to collaborating and trying to work through some of the details and issues that they have that I've raised and that'll be discussed with some of the other experts.
Madam Hearing Officer and Commissioner Bloom, I can proffer that, you know, I think we can probably make some more refined recommendations by the time we get to Ms. Felix's testimony, who does speak for NUMOGA, and probably potentially, you know, after the record closes or between the time when we have to submit findings of fact and things of that after the hearing.
Thank you, Mr. Suazo.
Yeah, thank you, Mr. Suazo. I appreciate that. I think you all see where I'm going, so I will end my questions here. Mr. Arthur, thank you for your time.
Thank you, and I do remember you from the pit roll, so.
All right. Thanks, take care.
Chair Chang, do you have questions of Mr. Arthur?
Could we go to slide 49? I have one quick question about Texas. Do you know how many orphaned wells there are in Texas at the moment?
I don't have that number memorized, but there's a lot.
More than New Mexico?
Yes.
And also I want to clarify, I believe one of the attorneys, and unfortunately, I don't have the transcript in front of me. Somebody asked something along the lines of whether you agreed that financial assurance is like insurance for the state. And I believe your answer was yes. Is that correct?
So I'm trying to think of this as a regulatory agency, because the questioning that came up there was when he was asking me how much insurance I have and so forth. And so it was a little confusing, but I would say essentially financial assurance works that way within reason, so that the state isn't stuck with some problems that you have to use state money for, or
functions to insure for a liability,
yeah.
Right? Okay. There's been some discussion around, I believe you've used the term bad actors when talking about in your testimony. So I wanted to sort of explore that a little bit with you. It seems, I guess I'm trying to connect the dots between whether somebody is a good actor versus a bad actor and how that ties into the need for insurance, and how those two concepts relate to each other, if they do. Because you bring up bad actors. It seems to me that good homeowners, bad homeowners would want homeowner insurance regardless, right? I'm sure your counsel is a good attorney and not a bad actor, and yet I'm going to go out on a limb and presume that they carry malpractice insurance. And we require bonding for a range of professions in New Mexico, if I recall correctly. Everything from contractors to title service companies to notary publics. I presume that I haven't seen anything that says, only bad actors in the notary public space are required to bond, or that only bad title service companies are required to bond. So I guess I'm trying to figure out, wouldn't the good or bad, first of all, I'm not sure that people would agree on whether or not they are in fact good or bad actors, but just assume in that scenario, wouldn't that factor into the premium that is charged for the amount of liability that one is required to carry, as opposed to whether or not liability in and of itself is required?
I think that's part of what I was looking at is, is a risk-based approach. So that's essentially like blanket bonds, or, that gets part of it. But if you have an operator, let's say, that has a very good compliance record, is doing all the things that they should be, that, so forth, should that go into the consideration of what their bonding or insurance in those terms should be? So if you want to go get car insurance and you have 3 DUIs and 4 wrecks, you're going to pay a whole lot more than, somebody who's a perfect driver and never even had a speeding ticket.
Right, and that would be factored into how the insurer calculates your premium, isn't that correct?
I'm not the insurance person within that, but so I don't, NUMOGA has a surety expert that's going to talk about that. But I would also say that regardless of that, in my experience, oil and gas agencies across the country have looked at, what they believe their risk is too. It just is New Mexico has done here with having blanket bonds.
Sure, understood. You brought up car insurance, and New Mexico as a state has a minimum liability requirement for all drivers. Doesn't distinguish between good or bad drivers. There's a mandatory minimum that we must carry, right? And so the question of whether or not somebody is a risky driver, at least for the purposes of the state mandatory minimum, that doesn't seem to change. But what changes is how much a insurance carrier will require you to pay in your premiums. Isn't that the way insurance works?
Again, I'm not an insurance expert on that, but what I will say is that since we're talking about car insurance, I'm going to bring up something that's not very pleasant, but New Mexico also has uninsured drivers that are non-US citizens that drive on New Mexico's highway. And I know that from personal experience, because 2 non-US citizens 2.5 years ago that were driving a semi truck after being up for over 20 hours crossed the median and ran into my father-in-law and his wife's car and killed them both instantly. So the New Mexico is allowing uninsured drivers to come through the state.
Well, I won't claim to be an expert in the statute on car insurances, but it seems like there is, as far as I understand the statute, people are required to have a mandatory minimum, and certainly there are people who break the law, right? So
my only point is what I was really only trying to get to is that typically in my experience, I'm not an insurance expert, so maybe that should go, those specific things should go to that one. But what I have seen is state oil and gas regulatory agencies that look at the operators that they're managing and the risk, and typically you have financial assurance that's risk-based, that blanket bonds and so forth.
That's all I have. Thank you.
Thank you, Mr. Chair. There's no reason not to excuse Mr. Arthur. Thank you very much, Mr. Arthur, for your testimony.
Thank you.
Mr. Chair and Commissioners, it's approximately 11:30. We can take an early hour for lunch, come back at 12:30, or we can press on with Namoga's next witness. But it's likely that your next witness is going to take more than an hour. Is that correct, Mr. Swaza?
Most certainly.
Great.
Is Felix next?
No, it's actually our surety expert, Mr. Emmerich.
What say you? Early lunch, maybe?
Yes, always down.
Or for some of you, second breakfast? Okay. 12:30, please.
Second, Commissioner Chang. Yeah.